This is Government 2306 with Philip Crosby. I left you last time wrapping up the special purpose districts on Unit 3, looking at the bureaucracies and the relative execution of some local laws. And so effectively, we're going to wrap up Unit 3 there, leave that, and move on to Unit 4. Unit 4, we've already prefaced. The last lecture I gave you before I left was in this construction of justice and how do we construct justice, how do we understand justice, and really kind of ask ourselves to what extent justice can even exist in a modern society. Remember, we centered on that quote that Plato said, justice can only exist in a society to the extent that it exists first and foremost in the hearts of its citizens. And this is quite problematic for us because as much as we want to build on this kind of idea of justice and demand justice, a lot of what we call justice in the United States is really something more that looks like reciprocal vengeance. It's kind of like somebody was hurt, so we've got to hurt them back. Somebody needs to be punished without really understanding what is punished. And so we left off this kind of conception of justice by looking at this narrative of we've created the Justice League. In other words, we are so far from really identifying a consistent narrative on what is just that we continue to create new variations of justice, and those variations continue to pit themselves against each other in this kind of feud regarding justice where anybody can pick their hero. And this creates a lot of complications when you look at modern society. I mean, if you're an idealist, you've got Superman. If you're kind of like somewhat tainted, you can pick Batman. And Wonder Woman gives us the feminist version of justice. And everybody just kind of picks their own version of justice and runs with it. But the problem is if everybody's picking their own version of justice, then it really becomes complicated on whether or not any singular version of justice can actually manifest within that given society. The Marvel universe does the same thing. When you really think about it, Marvel may do this a slight bit better. At least they make better movies. But a lot of the characters are very similar. Iron Man is very similar to Batman. Captain America, very similar to Superman. So when you start looking at the comparisons, the characters, the facades, the manifestations are a little bit different, but underneath it's still that kind of conception of justice, this kind of idea that there is some sort of good that we are supposed to be defending and fighting for, but they don't always agree on what that good is or how to fight for it. And so we're left with this kind of conception of justice on saying maybe justice really is blind. Maybe it's something that we really don't know, and we're just kind of like blindly wielding a sword, and we have this unequal balance that we can't see anyways. Even if we wanted to see the balance, we couldn't see it. Or maybe justice is a lost concept, that it's nothing more or less than an ideal. This kind of, something like hope or mercy or something we talk about a lot, but to actually put it in words or manifest it is something quite different. And so what we're going to do is I'm going to try to steer clear of the concepts of justice and actually get into judicial redress. In other words, what I'm going to try to do is try to separate the idea of justice from the idea of judicial redress, the power of judicial redress. In a sense, the power wielded when we actually talk about the judicial redress or the court system, we do not have courts of justice. We have courts that exercise a judicial power, and that judicial power usually takes a form of some type of redress. And so we need to kind of look at the narratives today on the courts of law and what they actually do. To do that, we're going to have a little bit of a lesson of the history of law on how is it set up, why is it set up, and when you go to court, what is actually happening there. And so the first thing you need to kind of put down is the foundation of law. There are two types of law. Two bodies of law, two systems of law, two very different approaches to law. We have criminal and civil. Criminal law is going to be what we call laws against the state. There is some existing entity that has crafted a law, right? A rule, an order, something like that. So if I get into criminality, there is something that the state, the group, the entity has said, this shall not happen. This thing is wrong. And the individual, right, willingly went against the will of the group. Right. So when there is a purposeful breaking of the group will as it manifests in the written law, that is what we call criminal law. Criminal law seeks to guarantee that the customs, or not the customs, but the moral parameters, if you will, of the group are upheld, right? And so we have these in a lot of different forms. Minor rules are going to come into minor indictments, not minor indictments, but minor infractions, and big rules are going to get you in a lot of trouble. So we have big rules. If you break those are called felonies. We have minor rules. Rules, if you break those are misdemeanors. And so we have these two types of rules that we're going to look at. That these are things that you did that broke the moral code of your whatever you're at. It could be the state. It could be a locality. It could be a nation. Whatever entity that set up that rule. If you broke it, that's the entity you have to square with. Because now, since the individual has broken the will, the moral will of that community, that individual is going to have to reconcile with the community in some form or fashion. So the criminal process allows some type of restitution, some type of remediation, some type of repentance, if you will, on something that criminal has to do in order to make right that wrong of violating the standards that were produced in the collective. So like I said, felonies are big ones, misdemeanors are small ones. We'll look at kind of examples of both those. Grand jury trials, these are often kind of misnamed, and a lot of people have no idea what they are, but a grand jury is like a pretrial. It's one that guarantees the assurance of rights and the assurance that we're not wasting our time when we try to penalize criminals. In the United States, we have very, very strong protections against criminal rights, or in favor of criminal rights is a better way to put that. In other words, it's difficult to be criminally accused and processed and convicted. We have a lot of things in the United States that guarantees that if you're convicted of a crime, you have rights, and whoever is convicting you has to uphold those rights before penalizing you. So the grand jury is going to be this entity, it's a group of people that's called together that asks the court to say, you have the state that's accusing you of breaking the law. Now we're going to have a group of people called a grand jury. This group of people is going to look at what the state is saying and determine, does the state have evidence enough to prosecute? In other words, is there enough evidence to even take this to trial? Before we get a judge and a full trial and all the paperwork and everything else, we're going to have like a pre-trial, something called a grand jury, and they're going to look at all the evidence and they're going to ask, is this worth going to trial, yes or no? If the grand jury says yes, there's enough evidence, then a trial is scheduled. You actually go before a trial, the evidence is done, you have lawyers and a bunch of other stuff. If the grand jury says no, there's not enough evidence there, you are released. Right? You are released with the state's apologies. Effectively, they're not saying you're innocent, but what they're saying is there's not enough evidence here to convict. In the United States, the history of criminal proceedings is innocent until proven guilty. So it is on the state or the entity to prove beyond a shadow of a doubt, beyond reasonable doubt is what they call. All right? The burden of proof required to convict is beyond reasonable doubt, which is a very high threshold to reach. And so in the United States, if the court cannot get to that threshold beyond reasonable doubt, then effectively you're released with the court's apology. The other two kind of definitions here are the indictment. The indictment is nothing more or less than the accusal. When you are indicted, you're accused. Indictment is not an admission of wrong. An indictment is not guaranteeing your guilt. An indictment is simply saying the state is saying they believe you broke this law. Now there's going to have to be a court proceeding or something. There has to be some type of reconciliation of that error. All we're saying with the indictment is there's a break. The group has a group moral norm, and the group is saying you broke that norm, right? So there is a divide. There is a division here, right? There's something now separating, and we have to build a court case, some type of mechanism that pulls y'all back together into some sort of harmony if you're going to continue living in that society. That's the judiciary. That's the judicial power. It's the power to bring two individuals or a group with the individual back into harmony, so we don't have continued ailment or continued violence within any given society. A proper understanding of the judiciary is nothing more or less than that. It's not really about bringing this highest form of vengeance or justice or the ideal perfect state. In the modern iteration, the judicial system, all it is an attempt to harmonize against the wrongs that occur in society. Now, criminal law are wrongs that should not have happened. There are laws against them, and you broke the law, right? And so we're looking at what law did you break, and is there enough evidence to accuse you in court of breaking that law? And if you did break the law, then, and we show it, there's a remedy. Notice the remedy. There's something you have to do. So you may lose your property, you may lose your freedom for a while, be in confinement, or you may even lose your life. The worst punishment that we levy on criminally accused is loss of life. And again, all this is an attempt to make right the group, to make right the grouping. And so a lot of people argue with the court, with the capital punishment, that if you are in fact a murderer, if you are a violent person, the group can never quite feel safe. The group can never quite feel in harmony. And so the only way to bring harmony back to the group is to eliminate you from the group. And so one could reasonably ask, then why not just banish them, which we have historically. Historically, banishment has been a popular form of punishment, that if the society did not want to levy a full life penalty, they could simply be kicked out of the nation. The problem with banishment today is there's not a lot of uncharted territory to banish to. You'd have to banish to another nation, and another nation isn't going to be the first one in line to pick up a murderer. So we have kind of complications on how do we actually make right the group in the midst of an individual who openly broke the law. And so when you start looking at some of these are just kind of an example of what we're talking about. You have on this side felony crimes and the misdemeanor crimes, and it's kind of fun for me always to kind of look at what do we consider criminal behavior and what are like the big crimes versus like the not so big crimes. And so at the top, capital punishment at the top, and you will get death or life in parole. These are the Texas ones, which is important to note because death and life without parole, death specifically, is only done in a handful of states. I want to say 23 states, something like that. Don't quote me on that. Still actually uphold the death penalty. Most of the United States do not have the death penalty. The worst you'll get is life in prison. But it is important to know that in a handful of states, you can look at the death penalty. And some people have argued that this is fundamentally unfair, that if we look at a nation with equality, if I commit a murder in Texas, I could actually face death as a punishment. But if I commit murder in California, I would not ever face death as a punishment. And so there's some inconsistencies that go along from state to state to state. But overwhelmingly, we have still allowed states to determine what are going to be the day-to-day moral norms of your state, and the court system has kind of backed off of a lot of micromanaging of what they consider criminality. And so these criminality and the punishments are largely set by the states individually. First degree, these are first degree felonies, all right, aggravated using weapons, assault on a public servant. This is a big one that is near and dear to a big reason why we're seeing a large percentage of specifically young men in prison for a long time. If you have an encounter with a cop, and let's say you're a cop coming up and you have a small dose of drugs, right? And people are like, well, so many people are in prison or in jail because of drugs. Actually, what happens in those circumstances a lot of times is that young man, when approached with a cop, gets very belligerent very quickly. And that belligerence with the cop, if the cop goes to grab the drugs or goes to arrest the individual, and the individual pushes the cop, shoves the cop, swings at the cop, Now it goes from your basic kind of drug kind of accusation to an assault on a public servant. If you look at where drugs come into this, whatnot, second degree, you have to have a lot of marijuana for a second degree, right? Third degree, whatnot, usually your low-level drug possession is going to be somewhere in the misdemeanor element. Felony, depending on how much you have and what type the drug is. But like I said, it's complicated, and this isn't the venue to do that. But a lot of times what happens is because a lot of the criminally accused, when they're interacting with the cop, lose their cool, and they actually end up having a violent exchange with the cop, that this extra thing, assault on a public servant, is added to the list of accusations that the state makes. And what's interesting with this list of accusations, it's no longer just an accusation. Now, a lot of these are caught on the cop cams. A lot of these have eyewitness testimony by other cops in the vicinity. And once you push a cop, that's done. And that's going to become with, 5 to 99 years in state prison and or a fine up to $10,000. And so one of the things that it's important to teach is like you need to understand as you go into crime and criminality and the convictions that you may face for whatever crime you're doing, guys. If you have possession of drugs, most people don't walk away from that saying, "Oh, I didn't know I didn't do anything wrong." Right? The problem is when people do something wrong and get caught, they don't always respond civilly or civilized in a civilized manner. Right, there you go. There's your humor for the day. A lot of times emotions get high. A lot of times emotions get overwhelming. And a lot of times the broader context of that causes an elevation of the accusation because, like I said, they get belligerent, they get violent, they push, they shove, they do something else. Third degree burglary, you look at these arsons on here, a bunch of other stuff, burglary of a vehicle, second DWI. We actually take DWIs very seriously in Texas. So thing, prostitution technically still on the list. You still cannot do it. It is still a misdemeanor. Terrorist threats, whatnot. Public intoxication is a Class C misdemeanor. Disorderly conduct, however we define that. So all of these are going to say these are things that the state or the group has said you should not do. And if you do them, you could face some type of punishment for doing them. And this is kind of important. The other type of law is going to call civil law. Civil law is when two individuals are kind of finding themselves at an impasse of their own reconciliation. So civil law is when I have person A, all right, is in conflict with person B, and they cannot reconcile the conflict. There's a conflict in the middle of them, and for whatever reason, they cannot navigate on their own that conflict, right? They require some other entity, some third party, some court system to help develop that dispute and settle that dispute. And the reason why the state may offer that really what becomes a service is so that we don't have a continuation of private individuals taking matters into their own hand. And so if person A is a homeowner and person B ran a car into their fence accidentally, person B, by destroying the fence, didn't break any laws per se, but because the fence was destroyed and it was their responsibility, is person B responsible for financially compensating A for repair of the fence? Well, this is what we call civil law. It helps develop a dispute resolution between two or more private individuals. And this is very important to understand because depending on the type of law you're facing or how you're going to court, you're going to be doing something very different. So if I look at murder, I'm going to criminal court and I'm facing criminal law and I'm looking at punishment. If I'm going in for divorce, I'm looking at civil law and we're not trying to determine punishment. We're just trying to find a proper resolution so that exchange doesn't escalate to the point of violence or escalate to the point of criminal behavior. And so civil law has this kind of dispute between two or more. This is where you get into tort law or civil wrongdoing. Tort law is a big area of when you get into, I stepped off a curb and hurt my back, so somebody is responsible for this. Somebody didn't do what they were supposed to do to adequately protect me. And we're always talking about tort law or tort law reform. Some people have argued that the absurdity of this has gone overwhelmingly. Some people have said it's not gone very far at all. And this is something that's always kind of in flux. If I go to McDonald's and McDonald's serves me coffee that's too hot and I burn myself, is McDonald's responsible for the burning of that coffee? This was a prominent court case that came up in the 90s, and a court said yes. And this is somewhat problematic because this is where, once again, we like to confuse everybody, because the payout for McDonald's was astronomically high. And a lot of people say, well, the payout was too high. But the individual showed that McDonald's was in the wrong. They were openly and knowingly violating the regulatory standards of restaurant practices. The problem is the regulatory standards of restaurant practice aren't necessarily laws of the state. They're simply laws within a business industry. And so the fine that McDonald's had to pay was a little bit of a punishment, which is technically the hallmark of criminal law, but then it was assigned in a civil law case. And so some of these tort law and civil law begins to blur the line between civil law and criminal law and the purposeful intent, which does make it difficult to understand the difference between these two and how they operate. Nonetheless, tort law is following that thing of what happens if a civil wrong is done. Somebody had the responsibility to do something, they didn't do it, and somebody else was hurt. Again, nobody broke the law per se, but something was harmed. One of the biggest things you need to understand about the courts is the courts are passive organizations. They do not come to you. You have to go to the courts. The courts are passive in nature. You have to file. You have to set up court cases. You have to go there. Property disputes are a big one. Line disputes, property disputes, land disputes. Who actually has the land? What can you do with the land? And what we try to do in most of your civil court cases is mediation and arbitration. Mediation is when you have a state employee that works with you hand in hand. They sit down with you. They try to get you to agree on a settlement without having to go to court. If you go to court, it costs a lot of money. You have judges, you have juries, you have paperwork, you have clerks, you have all kinds of stuff. And at the end of the day, as much as we say, I'm going to take you to court, there is a whole lot of money that is required in going to court. You want to avoid court if at all possible. The other big thing is that we often use the same courts for both criminal law and civil law. So the more we go to court with disputes between individuals, the more the courts are going to be backed up in the area of criminal law. And this is something that is important to understand, because overwhelmingly the biggest issues right now being kind of fought out in our courts are divorce issues and child custody issues. So when we look at my cousin was convicted of a crime, didn't get a fair settlement, or had a rush settlement, a lot of times when you look at what is backing up the court, it's not criminal proceedings, it's these civil proceedings. A lot of what the court is backed up with today are the fact that we as human beings can't get along, that we cannot see eye to eye and simply find a fair settlement with each other. And we're requiring a third party entity, something else, some other thing to help us get along. And that in and of itself, one could argue has an element of injustice with it, that we have individuals accused by the state and sometimes they don't get a fair process, they get a rush process because we have other individuals that are willing to pay the money to go to court to fight each other, fight out their divorce issues, fight out their child custody issues, fight out their family disputes. And child custody, guys, is an injustice in and of itself. When you actually start looking at what happens in child custody disputes and putting 8-year-olds, 7-year-olds, and 6-year-olds in the midst of a criminal in a civil proceeding and ask them, which one do you like better, mommy or daddy, and who do you want to live with? That question alone posed to a 7-year-old is just an astronomically difficult question with a lifelong psychological consequences. And so when we start looking at this, the best thing is really to try to solve it before you ever go to court. Try to find somebody, a third party, that can help alleviate the tension, reconcile the differences before it ever goes to court. Arbitration is like mediation, but it's a little bit different in the sense that arbitration is like a judge. An arbitrator kind of carries the role of a judge, except the difference is you don't get the full court. You agree it's a lot cheaper. You don't get the full court proceedings, but the arbitrator can listen to both sides and basically hash out a settlement, and whatever that arbitrator decides becomes the final settlement. So mediator kind of gets y'all to kind of helps guide y'all to a solution. The arbitrator gives you the solution. Here's what we're going to do. Once you have arbitration or opt for arbitration, whatever that arbitration says is final. You would have to appeal it to a judge, and a lot of times the judges are not going to override the arbitrator, simply because if judges start overriding a lot of arbitrators, then their jobs get a lot more difficult really quickly. And so that's the difference between mediation and arbitration. At the end of the day, we're trying to get a settlement, all right? Some type of settlement between the two individuals. Again, overwhelmingly, the purpose of the courts, the purpose of the judiciary is to settle disputes, to bring some type of remedy, to bring reconciliation, to potentially parties that are at odds with each other. Civil law, the parties are independent in nature. They're kind of fighting each other. Criminal law, the state is accusing a party of breaking the group norm, the group behaviors. The other big thing that's very, very important to understand is this, that in civil law, if you're proving that a harm was done and that harm needs to be reconciled, all you have to prove is a preponderance of the evidence suggests that they're responsible for it. Notice the difference between that and criminal law. In criminal law, the state has to prove beyond reasonable doubt before a punishment can be levied. In civil law, all they have to do, whoever's accusing you, just has to show that a preponderance of the evidence suggests that you're responsible for the harm for a judge to award things. So in a lot of times, you may not be kind of convicted of a criminal law or a criminal breaking a criminal law, but you may still be liable for a civil law. Famous case of O.J. Simpson. O.J. Simpson actually was convicted of murdering his wife. He went to criminal court, and the criminal court said that there wasn't enough evidence. Notice they did not say he was innocent. They said there was not enough evidence, that the criminal prosecution could not get to that threshold of beyond reasonable doubt. And so they could not convict. And that's something that's really, really important to understand, guys. In criminal proceedings, when they release them, they're not saying they're innocent. What they're saying is, we cannot prove that they're guilty. And there's an assumption of innocence. I have to prove guilt. So if you can't prove it, we let them go. Right or wrong, better or not, we let them go. We simply can't prove it. However, O.J. Simpson was still accused by the family for personal wrongdoing and actually underwent a civil trial as well, which has a lower threshold. And so the remedy in civil is restitution, usually through monetary compensation. So in other words, once again, right the wrong. So if you broke my fence, then you pay for the fence, we're good. Now, again, if you broke my fence and offered to pay for it on your own, and we did this, there's no reason to go to courts, right? We can actually resolve that conflict on our own. So once again, what we're talking about is not really this idealistic construction of justice. What we're talking about is a power that's held by the state that helps alleviate tension within the state. So the judicial power is this kind of last power that helps alleviate the tension, keep it from growing, keep it from breaking, and keeping the more violent components of societal exchanges from ever manifesting. That's what the courts are trying to do. So this is taken from the English Law Dictionary. It's a great way to understand the difference between civil and criminal law. Argues that the difference between civil law and criminal law turns on the difference between the two different objects law seeks to pursue. Notice that criminal law and civil law are doing two different things: redress or punishment. One of them is redress, the other one is to punish. The object of civil law is to redress of wrongs by compelling compensation or restitution. The wrongdoer is not punished. So notice, in civil law cases, the wrongdoer is not punished. So it was an accident. In civil law, you're looking at, if you're going to have a society of 330 million people, people are going to run into each other. They're going to bump into each other. They're going to hurt each other on occasion. And not every time you get hurt was it done on purpose. And so what we have to determine is, how do we actually parse this out and say, I'm not trying to punish you, but you still hurt another human being and you need to make that right. That's civil law. He only suffered so much harm as is necessary to make good the wrong he has done. And so in civil law, right, we're really looking at how do we actually make right the wrong. That's what we want to do. The person who has suffered gets a definite benefit from the law, or at least avoids loss. So it also protects me as an individual citizen. If somebody is out there and they hit my vehicle, that they're responsible and their insurance needs to protect me from that potential harm. So I have some protection of the law against the carelessness or accidents of others. But look at the difference on criminality. It says, on the other hand, in the case of crimes, the main object of the law is to punish the wrongdoer. This is something that I have argued with school officials for some time. Why do we punish? What is the point of punishment, right? If we have good punishments, how do we determine a good punishment from a not good punishment? And this is something that's really, really important to understand. So this is the English Law Dictionary. This is like the backbone of all American law. And it's arguing that criminal law seeks to punish the wrongdoer. And then we have the semicolon, which means there's going to give a reason following this on why we punish. So the first reason we punish is to give him and others a strong inducement not to commit the same or similar crimes. So in theory, a good punishment would see a reduction of the behavior. So if I have set up a proper punishment for some crime, the preponderance of that crime in my society should go down. If I'm not seeing a drop in the crime, then the punishment that I have decided is not effective. It's not a good punishment. As a teacher, if you are not seeing a decrease in, right, the actions that you're trying to decrease, then check the punishment. Right? Something that we don't understand is proper punishment, and the judicial system is wrapped with proper punishments, and this isn't always easy to understand. But a punishment should always have an outcome, a measurable outcome, to give him and others strong inducement not to commit the same or similar crimes. The second one, to reform him. This idea that to reform him if possible, all right? We're trying to make right the wrongdoer. So if I had somebody that was willing to break the moral code of the group, right? How do I actually pull that person back into the group and have that person, right, no longer break those moral codes? This is something that's tough for us, because once we see a criminal or criminally accused, we see somebody in handcuffs, we see somebody kind of wronging, our brain kind of immediately separates us from them, saying, no, they're a wrongdoer. They're outside of our group. We can't let them play in our group anymore because they're bad people. They're murderers. They're thieves. It's really, really hard when you begin to reconcile this group dynamic. But if we're going to say that possibility of reform is there with all criminally accused, then what punishments would lead to proper reform? What punishment, what could that individual do to show the group that I'm okay to play with again? I'm okay to trust within your group, especially if they've done some heinous crimes. This is not easy. So punishment should see a decline in the action. It should see a reform of the individuals. And the last thing is perhaps, right, the third reason it provides, satisfy a public sense that wrongdoing ought to be met with retribution. And if we take this criteria, it gives me a threefold criteria on how to judge the effectiveness of punishment. So if I actually begin looking at something like the death penalty, does the death penalty accomplish these three criteria? Well, does the death penalty, number one, give the accused a strong inducement not to commit the same or similar crimes? I would answer no, it does not. Why? Because remember, when I showed you that graph between Texas and California, we saw very similar graphs in Texas, California, and New York in spite of the acceptance of the death penalty. In other words, we didn't see the death penalty really lead to a drop in the most heinous crimes. It's just not in the data. And so for the first one, it's like we don't see him. Now, some people are like, well, he's not going to do anymore because he's dead. Fair enough. That is a fair point. The person that we are accusing of and we're levying the death penalty on is not going to commit that crime. So that's given the obvious. So we have to look at the second component of others. Do we see others committing that crime as well? And so those people are like, well, he's not doing it. It's kind of misappropriating the definition, I think. The second one is to reform him. Once again, if they're dead, there's no reform. Now, some people are like, well, the push of death can reform. It can push people to kind of conversions upon death, guilt upon death. Death kind of does some funny things. And so there is an argument that if I push somebody to death, then maybe we do get that reformation at the end. That's a slippery argument, but I have seen people make that argument. So the second one, I would argue no. Maybe somebody says yes, but it's still not clear. And the last one, satisfy a public sense that wrongdoing ought to be met with retribution. It seems that the only clear reason to continue the death penalty is to satisfy our sense that they should be punished. And it doesn't really accomplish the greater good that we would want our punishments to accomplish. And this is something, like I said, that's near and dear to my heart, because a lot of times, because we don't understand what law is supposed to do, we uphold really bad laws. And not only do we uphold really bad laws, but we as parents continue to uphold really bad punishments. Even though we can't really defend our punishments, we still uphold them. We still punish in ways that demeans the individual, that does not seek to reform the individual, that does not reform this kind of broken relationship between the individual and the group. Teachers, overwhelmingly, I've had this argument as well, right? Teachers should create punishments that decreases the behavior. We should see a notable decrease in the behavior we're trying to stifle. We should always also see a reconciliation of that individual with the group. The purpose of the judiciary is reconciliation. It's harmony. It's to pull those individuals and ask, why did you break the group dynamic, and how do we get you back inside the group? Because if I have a person that lives outside of the group, they live outside of the social contracts that we develop within the group, they always are a threat to the group. And if you live outside of the group, the only real argument we have is confinement, prison, keep you away from the group. And this is something that we're doing without knowing that's exactly what we're doing. All right. When you go to courts, the courts are, like I said, passive in nature. This is going to be definitions. The book does this really well already. So I'm going to kind of fly through because I know recorded lectures aren't great already. Plus, recorded legal lectures are very much not great. The big things you need to know are what we call people. The plaintiff is the one alleging harm. The defendant is the one that's accused. And the way this works in criminal proceedings is the plaintiff is whatever law entity you broke. So if you have a speeding ticket in the city of Killeen, then the plaintiff is going to be the city of Killeen. It's going to be the city of Killeen, right, versus, right, me, Philip Crosby, and I'm going to be the defendant because I'm the one accused. The plaintiff is always listed first. The accused is always listed second. So if I want to know about any court case, that's how I parse this out. And notice that there's a versus. There is a breakdown. There's a competition. There is a disunity in every court case. In the civil court cases, what it looks like is kind of this. Whatever person, state, or entity on the one is fighting some other person, state, or entity on the second. And this happens on criminal proceedings or court proceedings. In civil proceedings, it's going to be the latter. It's going to be some person, whatnot, against another person, or an entity can sue another entity. But when you see the state involved, many times it's going to include some element of criminality because the state is the one that's setting up those moral norms for the thing. So the other big thing is Texas has a lot of different levels of courts. A lot of stuff going on in Texas courts, and they're very, 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 very confusing and complicated to navigate. And like I've said before, divorce and child custody are the prime issues. Most of the court cases that are filed in Texas courts deal with some type of familial dispute. Jurisdiction is another big thing. Jurisdiction is simply who has the right to hear your case. In other words, which court do you go to first? If it's original jurisdiction, that's the court you go to first, and you need to know this if you're going to court. This is one of the reasons why lawyers get paid a whole lot of money. If you file in the wrong court or go to the wrong court, you're actually going to find yourself kicked out of court, and you could potentially lose the case even though you never really started it by filing in the wrong court. Because legally, there's something called a statute of limitations, which is how long you have before you file a certain grievance. And so original jurisdiction goes to the court that gets the rights to hear your case first. Appellate jurisdiction goes to the court that gets to review your case. Notice that an appellate jurisdiction is not a new case. This is one of the biggest misconceptions with appellate jurisdiction. Everybody kind of loses a court case like, we'll appeal, we'll appeal, we'll appeal. Overwhelmingly, appeals are not even accepted. Not only do they not win, they're not even accepted. In order to get an appeal, what you're doing with an appellate court is that they're not actually hashing out the case again. To get an appeal, you have to show that something technically in the process of the decision making was done wrong. So a filing date was missed, a document was admitted that should not have been admitted. You have to show that the court, the lower court, when they made the original decision, actually broke protocol or did something outside of the bounds in the process of making that decision. Only then are you awarded the appellate jurisdiction. And so then the new court remedies that procedural element and then decides, without that procedural element, would there still have been enough evidence to convict, yes or no? And so what we see in an appellate jurisdiction is very different from a lot of times it's presented. The only exception to this is a lot of our small county courts that don't have enough of the staff. And this is happening. Remember, we talked about counties last lecture. 254 counties, and some of them are very small and very not well funded is a good way to put that. And so a lot of times they don't have the infrastructure necessary to properly chronicle the court. And so what happens is, if you go to any court, you need to look at, is that court a court of record? If it is, then the appellate follows the same rules. If that court is not a court of record, then if you get an appeal, you're actually appeal, and that appeal is called a trial de novo, or a brand new trial, essentially. So typically speaking, appellates do not give you a new trial. They're not going to rehash the evidence. They're simply going to look at procedural things, with the exception of if your original court was not a court of record. In other words, it just didn't have the infrastructure. Most courts are court of record, even the Killeen Municipal Court. If you go into the Killeen Municipal Court, you'll see it. It's big letters on the back behind the counter. It says court of record. This is in the book. Like I said, I'm not going to go. It's just what you need to know is the progression of this one. This is a passive organization. Somebody will go into the court at the lower levels, and you work your way up. These lines kind of move how you would move within the courts. At the lowest levels, you have municipal courts and justice of the peace courts. Municipal courts are known because they are attached to a municipality, a city. After that, you have county level courts. There's at least 254 county level courts because we have 254 counties, and every county is required to have a court. In extension, we have statutory authorization, which allows larger counties to have extensions of the county court. So the county court at law and the probate courts, they largely are extensions of the county court. So every county has to have at least a constitutional county court. And because some of the bigger counties, like Harris counties, have so many people in them, they set up satellites or extensions of that county court to deal with other things. So the biggest counties, like I said, have probate courts, and probate courts is what will families fighting after somebody is deceased. Green is really hard to see on that green background. Not that my random scribblings here are leading you in any way whatsoever to a better understanding, but nonetheless, so we have county level courts, which we have at least 254. Every county has to have one, and the bigger counties will have these extensions of their courts, and we call that statutory authorization. So they're authorized by virtue that they're carrying out the authority of the original county court. above the county courts, if you notice these black lines are appeals lines. So municipal courts and justice courts, they both appeal to the counties. So if you don't like what happens here, then the appellate court goes here. We also have county level courts with original jurisdiction. So depending on what you're going to court for, you may start at the municipal court, you may start at the justice courts, you may start at the county level courts, and you may start at the district courts. The district courts are the workhorses of the Texas legal system. Most of the issues are going to start in district court, but like I said, depending on why you're going to court, you actually may end up in a different place. Even with crime and criminality, depending on what you're accused of, you may start at one court or another based on the relative infraction or the severity of your infraction. All right, notice that county level courts, if you're appealed, they typically go to the Court of Appeals. Whatever goes to the district court, it typically goes to the Court of Appeals, with the exception of this line here, which goes all the way up to Court of Criminal Appeals. This is death penalty cases. If you have a case and you are actually convicted with the death penalty, you have an automatic awarding of an appeal. The Supreme Court of Criminal Appeals has to overview your case, make sure everything was done right, make sure all the T's are crossed, all the I's were dotted, all the evidence was submitted correctly. You get an automatic appeal for all death penalty cases. So there is an embedded kind of safety element in the Texas court system to guarantee that if this is you, that we do make sure that we follow the P's and Q's. The other thing that you notice is there's two separate Supreme Courts. So the Court of Appeals is kind of one unified body that carries this appellate jurisdiction or appellate function. If the Court of Appeals, right, isn't satisfactory, you can appeal it one level higher to the Texas State Supreme Courts. But one of them is a Supreme Court of civil matters and juvenile affairs, right? The other one is a matter of top criminal or adult criminality. So again, once again, at the bottom, it depends on what you're accused of, goes to which court. At the top, once again, depending on what you're accused of, will decide what court you end up in. I have it in the notes, a little bit broader breakdown. I'm not going to go over that here. If you want to pause the video, look at kind of what happens here. It's a really kind of good breakdown of how the courts are structured. Again, pause the video. You can read all this if you want to. It really kind of lays out what types of things would go to which courts, and also lays out the lines as well. All right. Last thing is judges in Texas. We elect judges in Texas anywhere from usually 6-year terms, but 4 to 6-year terms. And this is really, really problematic because judges are elected in partisan elections. So they're elected as Republicans or as Democrats. And this has caused much conflict and chagrin over the years, primarily because the question is, this puts judges in a bind and it puts the public in a bind. Because if a judge is elected because they're a Republican, now a Republican judge would have to continue to fit a Republican image in order to gain re-election. The more partisan we get in our nation, the more partisan it seems like these judgeships become. The question is, can a judge actually act fairly if they're simultaneously responsible to the constructs of justice and their voters? And this is a major problem. We also have appointed judges, which are another way that a lot of states do this. Texas does not. Texas, we elect our judges, but even the appointment of judges, depending on who is appointing them, can lead to a lot of political considerations within the appointment of judges as well. The Supreme Court of the United States is the best example of this, that we say that, well, we got better judges there, but not always. Even on the Supreme Court, we have ended up with some very politicized judges based on the president that was responsible for their appointment and what was the political balance in the Senate at the time. And so when we start looking at judges, one of the big questions is, if I'm going to have an entity that's responsible for reconciling disputes between individuals, then what should that entity be? What is the character and qualification of that entity? We know the reading for Unit 4 is Judicial Reform in Texas, a look back over 30 years. And something that Anthony Champagne does very well in that article is he kind of unpacks just how controversial the Texas judicial system is. And he really kind of shows that overwhelmingly Texas continues to get bad grades for our judicial system. The problem is we can't fix it. We can't agree on a fix. We don't know how to fix it. And in the light of not being able to fix it or have some agreement on a fix, we just kind of continue kicking the can down the road, so to speak, and the failed system or the struggling system continues as is. And it really leaves a lot of judges, good judges, trying to help fix the system behind the scenes, working with little pieces they can. I personally know a district judge that worked really hard to kind of, at least in his small world, try to build better courts and better processing. But, I mean, he was still subject to an electorate. He was still subject to the politics of it. And so this is something that we really do need more people paying attention to the system, understanding what it is, instead of going out and protesting with big signs about some idealistic conception of justice, actually taking the time to understand the system and figuring out how do we actually create a better system. Our punishments need reform. Our elections need reform. Our appointments need reform. Our understanding of how do we reconcile individuals with the group need reform. All of this needs a second look and a revamping, and yet if a perceived injustice happens to us, we get very angry, very upset, very willing. But if a perceived injustice just happens to exist in the entire system without a personal infraction, without me personally being harmed, we tend not to really kind of care so much. And so all these efforts to kind of fix the system or correct the system largely end up being without great resolve or great consequence. That's as far as we're going to go today. The next week, we're going to get into what crimes, a matter of justice, desert, and social prejudice. We have to look at a history of crime and criminality. We're going to look at the questions on is the criminal justice system in Texas racist, or are there other prejudices in Texas? What do we really need to keep in the back of our minds before we do this? But until then, I bid you all do. Make sure you take biweekly number 6, and please continue to email me, not text me, but email me and message me if you have any questions or concerns. Until next time.